ओके, डेटा प्रोटेक्शन और ऑनलाइन प्राइवेसी, इसका कॉन्टेक्स्ट क्या है? कॉन्टेक्स्ट बहुत सिंपल सा है. व्हाट्सएप रिलीज्ड इट्स प्राइवेसी पॉलिसी. बहुत ज़्यादा ऑनलाइन आउटरीच के बाद व्हाट्सएप ने उस प्राइवेसी पॉलिसी को डिले कर दिया है, रिवर्स नहीं किया है. इट हैज़ ओनली डिलेड इट टिल जून. ठीक है, तो we'll analyze what are the legal, constitutional and what are the other aspects of data privacy in India, how much secure is data in India, and what are the legislative frameworks that are guiding the data protection in India. ठीक है, तो first of all, privacy is a fundamental right. Privacy is a fundamental right under Article 21. Article 21 is right to freedom of life, liberty and privacy. ठीक है, right to freedom of life and liberty. Now privacy has been put under Article 21 by Puttaswamy judgment. Puttaswamy judgment in 2017. This is very important. ठीक है, प्राइवेसी इज अ फंडामेंटल राइट. तो जब प्राइवेसी फंडामेंटल राइट है वो भी आर्टिकल 21 के अंदर, दैट इज नॉन निगोशिएबल. इट डज नॉट, आर्टिकल 21 इज नेवर सस्पेंडेड. ठीक है, एंड इट इज अवेलेबल टू ऑल फॉरेनर्स एज वेल एज सिटीजन्स. तो व्हेन प्राइवेसी इज फंडामेंटल राइट, तो व्हाट इज द रोल ऑफ गवर्नमेंट? द गवर्नमेंट इज ऑब्लाइज्ड टू प्रोटेक्ट इट थ्रू लॉज और थ्रू एग्जीक्यूटिव एक्शन और व्हाटएवर. ठीक है, तो वाई न्यूज रिसेंटली? बिकॉज एज आई टोल्ड, व्हाट्सएप ने अपना पॉलिसी रोल बैक तो नहीं किया है, बट इट हैज डिलेड इट्स इम्प्लीमेंटेशन या डिलेड द एक्सेप्टेंस टू पीपल. It has actually bought some time for itself to explain to people as to what are the differences between the different kind of privacy policies. ठीक है, and WhatsApp subsequently also put a large ad in the newspapers about explaining कि how the privacy policy is not, the recent privacy policy updates are not going to affect the personal communications but only the business communications. ठीक है, okay, now what happens is WhatsApp is owned by Facebook. ठीक है, WhatsApp is owned by Facebook. ठीक है, now what WhatsApp is owned by Facebook. ठीक है, now WhatsApp is going to open marketplace in India. Marketplace मतलब online marketplace. WhatsApp is going to open online marketplace in India where a huge amount of millions of business transactions are going to take place. ठीक है, Facebook has its own marketplace. Fine. Facebook is it has around 1 billion users. ठीक है, तो अब क्या होगा कि when WhatsApp is going to open its own marketplace in India, तो यहाँ पे business transactions होंगे. तो what WhatsApp was saying is कि वो business transaction का डिटेल जो है वो Facebook के साथ शेयर करेगी और उन थर्ड पार्टीज के साथ शेयर करेगी जिसके पास जिसका Facebook या WhatsApp के साथ ट्रीटी है. ठीक है, दैट इज जो बिजनेस ट्रांजैक्शंस का डेटा है WhatsApp is going to sell to other third party firms and is going to share with Facebook. That means अगर आपने WhatsApp पे कुछ सामान खरीदा, आपके Facebook को पता चल गया कि आपने ये सामान खरीदा और आपको उसके रिगार्डिंग रिकमेंडेशंस आने लगे, एड्स आने लगे. This is very in the most of the simplest terms. However, the same was not applicable to countries outside countries in European Union. ठीक है, यूरोपियन यूनियन में जो कंट्रीज हैं वहां पे WhatsApp प्राइवेसी पॉलिसी डिफरेंट है या बाकी भी प्राइवेसी पॉलिसी डिफरेंट है. क्यों? बिकॉज ऑफ एग्जिस्टेंस ऑफ GDPR, जनरल डेटा प्रोटेक्शन रूल्स 2017. ठीक है, तो we'll try to understand what are these policy in Europe. While general data protection rules 2018 पॉलिसी इन यूरोप में क्या है? जनरल डेटा प्रोटेक्शन रूल्स. यूएस में क्या है? देयर इज नो ओवरआर्चिंग गवर्नमेंट पॉलिसी ऑन डेटा प्राइवेसी. फाइन, बट यूरोप में द डेटा प्राइवेसी इज वेरी स्ट्रॉन्ग इशू एंड जनरल डेटा प्रोटेक्शन रूल्स आर वेरी स्ट्रांगली एप्लीकेबल. ठीक है, जनरल डेटा प्रोटेक्शन रूल्स में 2-3 बेसिक रूल्स हैं जो कि हमारे एग्जाम पॉइंट ऑफ व्यू से इंपॉर्टेंट है. द फर्स्ट वन इज राइट ऑफ पोर्टेबिलिटी, राइट टू पोर्टेबिलिटी. The second was right to erasure. राइट टू इरेजर, ठीक है। राइट टू पोर्टेबिलिटी मीन्स एनी यूजर दैट has his data with some company, ठीक है, तो he can when he transfers one, for example, and a user has account on Facebook, Flipkart and on Amazon. I want that my Flipkart data should be shared with Amazon, and I authorize Flipkart to share my data with Amazon. That is called right to portability. In India, there is no right to portability. ठीक है, everyone's data is being sold online. We all know that data is the new oil. ठीक है, that is right to portability is, and when if I ask my Facebook, my data with Flipkart should be completely transferred to Amazon, so I am the owner of the data. ठीक है, and the Flipkart will then have to transfer my whole data to Amazon. Because I don't intend to take the Flipkart service anymore, I want to take Amazon service now. In that case, I will ask Flipkart to transfer my data. That is called right of portability. Now right of erasure. Now I ask Flipkart to delete my whole data. So Flipkart is obliged to delete it. ठीक है, इंडिया में ऐसा कोई रूल नहीं है कि अगर मैं चाहूँ तो मेरा डेटा कोई डिलीट करे. There is no law regarding that. The second important thing in GDPR is that there is a right of managing and retaining your information, similar to right of portability and right of erasure. ठीक है, and whenever I can choose to opt out, like for example, if any of you have chosen to opt in the WhatsApp privacy policy, now you cannot opt out of it. Either you have to delete the app. But in Europe, in European Union, you can opt out of the privacy policy. ठीक है, even after agreeing once, you can opt out. That is the right of like you can deny the access to your data to any other person. ठीक है, but that is not the case in India. What is the legislative domain in India? Indian data protection. India does not have a dedicated law that governs the privacy of individuals online. ठीक है, however, the Information Technology Act 2000 have some articles like 43A and 72A that govern our data privacy. The first one is section 72A. It is applicable only to individuals. ठीक है, it is applicable only to individuals. The act penalizes offender for 3-year imprisonment. If I have someone's private data and I leak it online, I am obliged to pay at least 5 lakh rupees compensation and 3 years imprisonment. This imposes, section 72A imposes criminal liability, ठीक है, on individuals, not companies. ठीक है, that is the problem. But this provision is only applicable to individuals, है ना, and rules are restricted only to even that data. What kind of data? Sensitive personal data, that is medical history, biometric information, sexual history, among other things. ठीक है, other data can be revealed. My photo can be shared with anyone. Section 43A of the same IT Act explicitly provides that when there is a corporate body, ठीक है, even government also, ठीक है, तो वो sensitive personal data अगर आपका किसी corporate body के पास है, for example Amazon, तो and if there is a breach of data, तो they are liable to pay you compensation. There is no criminal liability. यानी corporates और government पे criminal liability imposed नहीं है, बस individuals पे criminal liability imposed है, वो भी बस sensitive personal data like medical history, personal data के regarding ही criminal civil liability भी imposed है, criminal liability, sorry. But section 43 that deals with corporate entities and government, there is only civil liability, no criminal liability. That is only damage compensation will be paid and no imprisonment will not be done. ठीक है, so the law is very not very strict. Subsequently in 2011 the rules of regulation for data privacy were issued. ठीक है, the rules of regulation for data privacy. अब rules issue होते हैं तो वो किसी law के अंडर में issue होते हैं, that is IT एक्ट के सेक्शन 43A में के अंडर में ये रूल्स इशू किए गए, दैट इज every individual from whom the data is being collected should be aware of the fact that information is being collected. ठीक है, if your information is being taken by some entity, you should be aware of the fact, the purpose for which the information is being collected, the intended recipients of the information, the name and the address of the agency that is collecting the information and the agency that will hold the information. ठीक है, तो ये रूल्स 2011 में इशू किए गए, जो कि these are the rules that currently govern our data privacy online. ठीक है, but after 2017 judgment of 2017 Puttaswamy judgment on right to privacy, the government formed BN Sri Krishna committee, ठीक है, to look into the data privacy issue, ठीक है, and to recommend some measures that need to be taken. And BN Sri Krishna committee not only recommended measures, it also proposed a draft bill, data protection bill. ठीक है, ठीक है. And what were the foundations? From the individual consent. What BN Sri Krishna committee did was, it established individual consent as the basis of data collection. ठीक है, the first one is data principle, ठीक है. The second one is fiduciary, basically the data collecting या the data processing agency. There is a trust between them, ठीक है. The data is being held in the trust of the person. ठीक है, the data fiduciary is holding the data in the trust of data principal. If there is a breach of the trust, the data fiduciary should pay damages to data principal. That is the basis of the recommendations of BN Sri Krishna committee. ठीक है. And data fiduciary is liable for breach of data privacy of data principal. That means if my data is being collected by some company, that company is solely responsible for any kind of breach that happens on their servers, या whatever that happens, they are the one whom I should hold accountable. ठीक है. That is, for example, if a company is collecting my data, है ना, and it is holding my data somewhere else to third party, and at that third party my data is being breached, to the person who collected my data, that person will be held responsible. ठीक है. Identifies data, और दूसरा चीज क्या करता है BN Sri Krishna committee? It identifies data as two important things: critical personal data and sensitive personal data. Critical personal data is the very sensitive nature of data, like military information, है ना. तो ऐसा कोई प्रकार का डेटा है, सेंसर्स का जो इंफॉर्मेशन है, बिकॉज नाउ इट इज गोइंग टू बी एन एज ऑफ इंटरनेट ऑफ थिंग्स. ठीक है, पहले क्या था, खाली इंटरनेट डिवाइसेस आपस में ऑपरेट करते थे. नाउ इंटरनेट ऑफ थिंग्स में सेंसर्स, इक्विपमेंट्स, एलेक्सा, ये सारी चीजें आपस में इंटरेक्ट कर रही हैं. तो इन दैट केस अगर कोई बहुत ही क्रिटिकल पर्सनल डेटा लाइक किसी मिलिट्री पर्सन का कोई डेटा है, ये सारी चीजें क्रिटिकल पर्सनल डेटा में आएंगे. और सेंसिटिव पर्सनल डेटा में नॉर्मल इंसान का बायोमेट्रिक हो गया, है ना, हमारे अकाउंट्स का इन्फॉर्मेशन हो गया, हमारी एड्रेस का इन्फॉर्मेशन हो गया, ये सारी चीजें आएंगी सेंसिटिव पर्सनल डेटा में. एंड मैंडेट्स CPD विद इन इंडिया, क्रिटिकल पर्सनल डेटा का प्रोसेसिंग शुड बी डन विद इन इंडिया. ठीक है. एंड इवन इफ द सेंसिटिव पर्सनल डेटा इज बीन स्टोर्ड ओवरसीज, वन कॉपी शुड बी केप्ट विद इन इंडिया. ठीक है. However, there are a few exceptions. The state can process data without the consent. Again, we see on the ground of public welfare, ये याद कर लेना, बहुत important है. Public welfare, law and order, emergency situations where individual is incapable of providing consent, employment, and reasonable purposes. Again, reasonable purposes is a very vague term. Government can use this to its own end. ठीक है. तो this is all for the day.